domestic story and a huge one with implications for our politics. It's coming in from the state of Maharashtra, where nearly a year after Eknath Shinde's rebellion against the Shiv Sena leadership of Uddhav-Thackeray, the Supreme Court has declared that the status quo ante cannot be restored because Uddhav-Thackeray resigned without facing a floor test. So, Eknath Shinde gets to keep his job and Uddhav-Thackeray gets a moral vindication. But has it settled the Sena versus Sena war?
Had Mr. Thackeray refrained from resigning from the post of the Chief Minister, this court could have considered the grant of the remedy of reinstating the government headed by him.
A Supreme Court bench led by the Chief Justice observing that Uddhav-Thackeray's resignation last year was a mistake. The apex court declined to restore status quo in Maharashtra, which means that Chief Minister Eknath Shinde gets to keep his job.
जैसे सर्वोच्च न्यायालय ने कहा कि अगर मैं रिजाइन नहीं करता, मैं इस्तीफा नहीं देता तो शायद मैं वापस मुख्यमंत्री बन जाता। मैं मेरे लिए नहीं लड़ रहा हूँ, मेरी लड़ाई जनता के लिए है, मेरे देश के लिए, मेरे राज्य के लिए है। और भले हम इसके पहले राजनीति में विवाद तो होते रहते हैं, लेकिन एक मत तो हमारा हो गया है कि इस देश को हमें बचाना है।
Shinde and his deputy Devendra Fadnavis claimed vindication.
हम लोगों ने जो सरकार स्थापित किया है वो पूरी तरह से कानून और घटना इसका आदर करते हुए हम लोगों ने किया है, और जो जिनके पास बहुमत नहीं था उन्होंने रिजाइन किया है।
सुप्रीम कोर्ट बहुत स्पष्टता से कहता है कि गवर्नर साहब ने शिंदे जी को मुख्यमंत्री पद की शपथ लेने का जो न्योता दिया वो सही है। इसका ही मतलब ये होता है कि शिंदे जी के नेतृत्व में जो सरकार तैयार हुई है वो लेजिटिमेट है, वो कॉन्स्टिट्यूशनल है, और इसलिए हम सुप्रीम कोर्ट का आभार व्यक्त करते हैं।
But the Supreme Court did pull up then Maharashtra Governor Bhagat Singh Koshyari for taking decisions that helped the Shinde faction, like concluding that Thackeray had lost the support of the majority of MLAs and calling for a floor test.
जो मसला सुप्रीम कोर्ट में था, उस मसले पर सुप्रीम कोर्ट ने अपना निर्णय दे दिया है। उस निर्णय पर जो कानूनविद हैं वही अपनी राय व्यक्त करेंगे। मुझे नहीं लगता कि मैं चूंकि कानून का विद्यार्थी हूँ नहीं, मैं केवल संसदीय परंपराएं जानता हूँ और विधायी परंपराएं जानता हूँ। उस हिसाब से मैंने जिस समय जो भी कदम लिए सोच समझ के लिए।
The Supreme Court also said it can't disqualify Shinde and 15 other MLAs for revolting against Uddhav-Thackeray in June last year. That power will rest with the Speaker until a larger panel of judges rules on it.
तर यात त्यांनी स्पष्टपणे इंटरप्रिटेशन दिलंय शेड्यूल 10चं, आणि असं म्हटलंय की पॉलिटिकल पार्टीचं व्हिप ऍप्लिकेबल व्हायला पाहिजे.
Now the speaker will decide the disqualification, and then whatever happens it will follow. The Uddhav-Thackeray Shiv Sena party will remain into operation.
But today's verdict has only intensified the war of words between Uddhav-Thackeray and Eknath Shinde camps.
जितने भी रीजनल पार्टी है उनको एक सबक मिलेगा, क्योंकि आप देखेंगे जितना रीजनल पार्टी है वो फैमिली परिवार चला लिया, और परिवार अगर डिसीजन लेती है कि हम जो उनकी पॉलिटिकल पार्टी की कॉन्स्टिट्यूशन है, पॉलिटिकल पार्टी के विचार है, उसको छोड़ के अपोजिशन के अगर साथ परिवार जाएगा तो पार्टी नहीं जाएगी, पार्टी के कार्यकर्ता नहीं जाएगी। ये सबक ये डिसीजन के माध्यम से मिलेगा।
सुप्रीम कोर्ट का अगर आप निर्णय देखें तो हम खुश हैं कि देश में लोकतंत्र और न्याय व्यवस्था आज भी जिंदा है।
So will the Supreme Court verdict only give further ammunition to both sides to up the ante?
All right, let me first go across to our first top legal voice who's joining us. Satish Manshinde is a senior lawyer with the Bombay High Court. He's now joining us. Mr. Manshinde, what the court essentially has said is while the actions of the Speaker and the Governor may have been bona fide erroneous, but the status quo ante cannot be restored because Mr. Thackeray chose to resign and not take the floor test. So net-net, nothing really changes. While you can argue constitutional morality and otherwise, but politically or legally, the current government continues.
Well, what actually happened was very unfortunate in the sense that the electorate elected the BJP and the Shiv Sena together. And Uddhav-Thackeray walking away from the alliance was itself a stab in the back of the electorate. And I think ultimately the just desserts have been served in the sense that in spite of the fact that he was sitting in the Chief Minister's chair and the governor had asked him to prove his majority, whether rightly or wrongly, he chose to resign and leave the field voluntarily. It's like walking away from the boxing match. And he left no option for the Supreme Court to pass an order that was passed today, because the Supreme Court, if you remember, at the very initial stage, had said that how do you expect us to put you back in the saddle once having voluntarily resigned? And nobody asked him to resign at that time. And if you have seen Mr. Sharad Pawar's book, which has been recently released, I mean, even Mr. Sharad Pawar, who is the most seasoned politician of Maharashtra today, has said that his resignation left him in bad taste, and it was a totally uncalculated move that he took independently, and it totally showed immaturity on his part. First of all, he showed his immaturity in the sense that he did not even know that 16 of his MLAs who were provided with the security which Maharashtra government had offered those MLAs, left quietly and walked away to Surat in whatever manner. And he showed his inept handling of the situation in the sense that he did not even have the maturity to keep his flock together.
But Mr. Manshinde, hasn't the court also today, in a sense, rapped on the knuckles both the Speaker for his actions, saying that his appointment of the whip or his recognition of the whip was illegal, Mr. Gungale, the new whip who was appointed, and two, also the governor saying that the governor had no business asking for a floor test because this was an intra-party dispute and there was no material evidence to show that Mr. Thackeray had lost the confidence of a majority of his MLAs.
Well, the Supreme Court may have said whatever it has said today, but the governor, being in a tight situation during that time, was left with no option but to ask for the floor test, because in Bommai's case, the Supreme Court has always said the real test of strength of the Chief Minister is on the floor of the Assembly. And he did not want to see those people who were being paraded before him or the list furnished to him. So he asked him to prove his majority. Rightly or wrongly, he took a decision. In posterity, if the decision has been held to be wrong, then the next legal course will take charge.
But Mr. Manshinde, has this now set a precedent for governors that if there is an intra-party dispute, unless the MLAs explicitly say they are withdrawing support, and more than two-thirds of them say they are withdrawing support, there is no mechanism of a floor test, or it's not the business of the Speaker or the Governor to decide the strength of a legislature party?
See, there have been conflicting opinions. In Bommai's case, the Supreme Court said that the real test of a Chief Minister is on the floor of the Assembly. Now we have a judgment of this nature. Ultimately, the matter has been referred to a larger bench. And I think the larger bench will decide what should actually prevail.
Okay, Mr. Satish Manshinde, we'll leave it at that. We'll see how this story plays out. But it is an important marker, this, in many ways, more than one. You heard one legal point of view. To get the other side, Abhishek Manu Singhvi is senior lawyer in the Supreme Court. He was also representing the Uddhav-Thackeray faction in this particular legal fight. Dr. Singhvi, the Supreme Court has basically said that had Mr. Thackeray not resigned, status quo ante could have been restored. So really, nothing changes, and Mr. Thackeray is to blame because he should have taken the floor test. Even if he lost the floor test, the Supreme Court could have reinstated his government. But because he voluntarily resigned before the floor test, there's nothing the court can do.
The judgment says that the Speaker must decide the pending disqualification petitions, quote unquote, within a reasonable time. Now, let me tell you, if you are the Speaker and you pick up any of those disqualification petitions, Zaka, there is no other decision possible except disqualifying me. Why? Because that action, which is the subject matter of the disqualification petition, is only the action against the whip. That whip has now been validated by this judgment. Today the judgment says that the whip of the political party is the whip, not the whip of the legislative party. Now, all the disqualifications, or most of them, are the ones where the allegation is that you violated the whip.
Okay.
Now, if you violated the whip, there is nothing the speaker can do. The only decision he can do is to disqualify you. However, and that's what I said in the press conference today, it is for this reason that I expect and anticipate that you will get now delaying tactics started. You will have the speaker either deciding not to decide, or delaying the matter, or of course, since he really cannot decide anything but this, deciding something patently wrong, saying they're not disqualified.
But Mr. Singh, Dr. Singhvi, now in hindsight, I know hindsight is a wise thing, as they say, but the court is of the opinion that Mr. Thackeray should not have resigned, and had he not resigned, perhaps status quo ante could have been restored. So in hindsight, do you believe Mr. Thackeray was wrongly advised legally to step down before facing the floor test?
Nobody knows who advised him. Nobody knows whether it was legal advised. Nobody knows if it was non-legal advice. But let me tell you that wisdom by hindsight is always 20/20. Yes, in the light of what the Supreme Court has said, the matter, he would have had a different remedial framework had he not resigned. But the point is that today, the Supreme Court has said, the same court has said, you decide the disqualification. Okay, he resigned then. By the way, the basis of what he resigned was in the floor test. And the decision to call the floor test has been held to be illegal.
Yeah.
But let me assume that there was a mistake. Somebody advised, what advised, we don't know.
Okay.
But the point is, today, if the speaker were fair bona fide, if Mr. Shinde's statements were not the ones which are coming today, I'm told that he says it's nothing but a procedural issue, or the speaker says it's nothing but a procedural issue.
Okay.
But I can only say, Zaka, that we are living in Alice in Wonderland land then. Words mean what they say, what you say they mean. If these 5 substantive findings can be called procedural irregularities, then I think we have to relearn the English lexicon.
No. So while on the one hand you're right that the court has come down heavily both on the actions of the speaker and on the actions of the governor, but there is no material impact, because on the one hand it says that the speaker's decision to appoint a new chief whip was illegal, but it's not restoring the old whip of the party. It's also saying the governor's decision to call for a floor test was bona fide wrong, but it's also affirming the governor's decision to invite Mr. Shinde for the oath of office. So, net, the material aspect has not gone in Mr. Thackeray's favor. Maybe the moral aspect has, but the material aspect is not.
No. Please, you're mixing up. Every decision of high personages, high post holders like governor, speaker, and others has been declared, I repeat, declared by 5 judges to be illegal, which means it doesn't exist in law. However, what you are saying is breaking of the same point, that because he resigned, there was nothing the governor could restore. Now, if he has resigned, they cannot direct the governor to restore a person who has resigned voluntarily. That does not mean that there is any caveat in the holding that the governor is wrong, that the speaker is wrong, that the appointment of the whip is wrong, that the whip of the other chap, Bogavle, cannot be of any legal standing. Yeah. There is no caveat in that. It's unconditional. Yes, obviously, otherwise Thackeray would have been restored back.
Correct.
So therefore, the point of the matter is that in every which way you have been exposed. If you had any shame, which we are sure you will not do, you would have, gone. But today, we have no hope also of the speaker deciding fairly. I think we have to go to court again. It's as simple as that.
All right. Dr. Singh, we'll leave it at that. Let's see how this plays out. You have said that you will be going to court again because you don't expect the speaker to decide in your favor or decide at all in the first place. But let me also get in a view from the Shiv Sena Uddhav-Thackeray faction. Priyanka Chaturvedi is Rajya Sabha Member of Parliament of the Shiv Sena UBT. The Supreme Court basically saying that had your leader, the former Chief Minister, Mr. Thackeray, decided not to resign, the Supreme Court could have restored the status quo ante. In hindsight, was Mr. Thackeray badly advised legally? Was his resignation incorrect? And is that what cost him today? Yes, he has the moral high ground, but politically he's nowhere.
No, absolutely not. In hindsight or even as foresight, we are very clear that it was the Supreme Court which they're saying is unconstitutional, the governor's order for flow test, we had requested them for a stay at that point in time. The stay was denied. So as a moral responsibility, and having known that the court case hasn't gone in the favor of staying the flow test, he stepped down, and that is what morality would say. So in hindsight, in foresight, or as an insight, I can tell you one thing. This government is working on the basis of unconstitutionality. Two things important things that the judgment has said is A, legislative party cannot be acknowledged as a legal party, as a political party. So that's step one. Step two, that the whip that they had appointed is an illegal whip. Third, the flow test was unconstitutional. So now on the basis of a speaker's, trust vote, and the speaker getting elected, which is Mr. Rahul Narvekar, happened on the basis of an illegal whip, deciding who they will vote for. And the entire election of the speaker is based on the unconstitutionality of it all. So the question would now be, after the Supreme Court judgment, that this entire government has lost its moral authority to govern. It is an unconstitutional and illegal government.
The court has not in any way in today's judgment opined that the current dispensation is illegal or unconstitutional in any nature. In fact, it is said that while the governor had no business asking for the floor test for an intra-party dispute, it has said that he was right in his decision to invite Mr. Shinde to take the oath of office. So nowhere in today's judgment has the court said that Mr. Shinde's government is illegal and unconstitutional. So therefore, the government stands.
No, let me repeat to you, the government can stand, but morally it has lost. And I'll tell you, I've given you the sequence of events. These MLAs' disqualification is also going back to the speaker. The whip that will be applicable would be the whip decided by the political party chairperson, which is Uddhav-Thackeray, and our whip would work on those rebel candidates too. And anyone going against the whip stands to be disqualified. And that is the speaker's domain to decide. Second thing that the Supreme Court has ruled is that the Election Commission cannot decide on the basis of legislative strength whether the party belongs to that person who has more legislative strength. Thirdly, it is very apparent that without using the words illegal and unconstitutional, the steps that were followed to ensure the government came to power, the BJP, Shiv Sena, the Shinde Sena government came to power, came on the basis of an unconstitutional voting pattern. When your whip is illegal, how can he choose who to vote for? How can he make the speaker the speaker? Oh. So there are 40 MLAs who have gone against have gone along with the illegal whip.
No, so tell me now, what does Mr. Thackeray plan to do? The government of Mr. Shinde continues. The numbers are firmly with him. You may disagree about what the court said. I don't think the court anywhere said that Mr. Shinde's government is illegal or unconstitutional. You can disagree on that. How are you going to respond? How is the Uddhav-Thackeray faction of the Shiv Sena going to respond to this, both legally and politically? Can you hear me, ma'am? Okay. All right. I think we've lost that link with Priyanka Chaturvedi. We'll try and see if we can re-establish that. But essentially what she was saying is that they believe, the Uddhav-Thackeray faction of the Shiv Sena believes that today's judgment vindicates their position that the whip and the appointment of the whip was deemed illegal by the Supreme Court, by the Speaker, and also that the governor had no business calling for the floor test for what was essentially an intra-party dispute when there was no material evidence to show that the majority of the MLAs of the Shiv Sena were withdrawing their support or had lost confidence in the leadership of Uddhav-Thackeray. But that's not the view taken by the other side, the Shinde faction. We'll get our final newsmaker tonight on the show. Deepak Kesarkar is Maharashtra School Education Minister and also speaks on behalf of the Shinde faction. The Supreme Court essentially today saying that status quo ante cannot be restored because Mr. Thackeray decided to resign and did not face the floor test. For now, the BJP Shinde faction government is safe. But do you believe what the court said about the role of the governor, the role of the speaker, saying that some of their actions were illegal and unconstitutional? basically deprives your government of a constitutional and legal basis to stand on?
You'll have to understand one thing, that the written judgment has not yet received by us. At the same time, there are no particular guidelines how the governor should act in such cases.
Okay.
This is a good thing that now there are written guidelines. When situation like that arises, what decision the governor has to take, those guidelines are there, which will be very useful in future.
But the court has also said, Mr. Kesarkar, that the decision of the Speaker to appoint Mr. Gungwale as Chief Whip was erroneous, it was illegal. There was no material evidence to show that the MLAs were actually going to withdraw support to the Uddhav-Thackeray government, and therefore the governor's decision to ask for a floor test was also erroneous. So basically, both the constitutional authorities, governor and speaker, today's judgment basically nullifies their decisions, says that their decisions were illegal.
These things are not relevant now because Uddhav Thackeray has resigned and he has not faced the floor test. That is very important, and that's why here once you are resigning and the other side you are asking to be restored, that is being refused by the court, which is a very good decision, and we welcome this decision. And you must have observed that Uddhav Thackeray had never listened to Sharad Pawar. Sharad Pawarji has advised him not to resign. At the same time, in his own autobiography, he has clearly mentioned that Uddhav Thackeray was not meeting anybody, he was not meeting the people, he was not meeting the MLAs, not meeting the MPs, and that was the reason for the revolt that happened in Shiv Sena. That his autobiography remarks were also very rudely replied by Samna and Uddhav Thackeray fraction. And I think a senior leader like him should not have been treated like this.
But Mr. Kesarkar, you also heard from Uddhav Thackeray earlier this afternoon. He had a press conference jointly with the Bihar Chief Minister, Mr. Nitish Kumar, where he said that the Shinde government now has no moral authority or even constitutional authority to continue in office because the Supreme Court declared the actions of both the governor and the speaker, both of which resulted in the creation of this government or the paving of the way for the creation of this government, both of their actions as erroneous in law.
What moral he had to become the CM of Maharashtra with the support of Congress and NCP, who were rejected by the people of Maharashtra. The mandate of the people of Maharashtra is more important than anything else. And since he has resigned, the question of governor's decision does not arise at all. And as a whip, his whip, who is Mr. Prabhu, can always put before his part of the incidents before the Honorable Speaker, because they are claiming that attending a meeting not on the floor of the House, it is just not attending the meeting called by him, calls for disqualification. It is never written neither in the Act nor the rules framed under this Act. That's why I feel that these are all academic questions now.
But now that this legal hurdle has been crossed, Mr. Kesarkar, do you believe it's time for the BJP and the Shinde faction, the alliance now, to call for the BMC elections? And also, can you assure viewers who are watching this program that both for the parliamentary elections and the Vidhan Sabha elections in 2024, you will fight united as an alliance, that is BJP and the Shinde faction?
We are not Shinde faction, we are Shiv Sena, and we have that symbol also, and that is not challenged and not accepted by the Supreme Court also. We can function separately. That is what the Supreme Court has said. So we'll act separately. We are in alliance with BJP, and this is called Yuti government in Maharashtra, which will work for Maharashtra, people of Maharashtra, and will restore the back glory of Maharashtra.
No. So what about the question I asked? Will you call for the BMC election, something that you've been loath to do up until now? And will you fight both parliamentary and Vidhan Sabha elections in alliance next year?
all elections together, and we'll win
Okay.
it, and we'll work for the Maharashtra. Yes, certainly.
Okay.
And that too, Fadnavis Sahib has clearly mentioned that under the leadership of Mr. Shinde, the election would be fought.
All right. Okay. Deepak Kesarkar, we'll leave it at that. So you had two top legal voices and two political voices from either side of the Shiv Sena divide, as it were. We'll leave it at that. Like I said, as of now, there is no legal threat or constitutional impediment to the Shinde-Fadnavis government to continue, and so it will up until 2024 when the term of this assembly concludes. That's a wrap. We'll see you again tomorrow night, same time. Good night.